So I think that I will start. Thank you very much for being here. Our session is a little bit special, of course, because we will cover a very delicate subject, talking about offshore trust. And we will seize this exceptional opportunity for covering the black holes in the offshore system, particularly for people living in civil law jurisdictions and who are committing the crazy stuff of going through trust offshore. So the subject today will be divided in a few sections. I'll be very, very brief, on many subjects because we have a time limit. And the first part will be dedicated to some theory and some examples. I mean, true stories that happen to us today in our investigative job, the kind of problem that we are facing in Panama, the problem we have faced in Liechtenstein, with real foundations and trust with examples. So you will see that what I'm telling is not just bullshit, it's just the real life offshore. It is a nightmare. So first, 5 minutes dedicated to the UK website dedicated to offshore trust, to trust, where the British are explaining how good this institution is. And it is true, it is wonderful. If you create a trust in the UK, probably you are on the right track. Then, of course, we will jump into another world, the kind of trust that Belize is proposing, which is probably a good place, but not for everybody. Then Panama, 5 minutes. Then Liechtenstein with the famous trust set up by Giovanni Agnelli, who was the big boss of the Fiat Group in Italy, and who had the bad idea of creating a trust in Liechtenstein. But you will see that this trust was under clear control by key people who had the mission of making the life of his sole surviving child, Margarita Agnelli, a nightmare. Then I will briefly explain who is Mr. Batliner, probably one of the most important fiduciary men in Europe, who is living in Liechtenstein for a lot of years and will probably never have the slight of a problem, any problem. And then I will give you a few advices, and advice that will be probably useful if you want to go offshore, or if you have clients willing to go offshore, to think about. And if they don't think about what I will propose, probably they will be my clients within the next 4 or 5 years. So let's start with the easy part of the presentation. I'm sure that all of you know what a trust is, but I would like briefly remind you what it is. So this is exactly something coming from an official website. Talking about the trust, it's coming from the government UK Trust and Taxes type of trust presentation available to anyone. Hello Dan, you're most welcome. I'm just starting. So I'll be very quick on this because I have only 5 minutes for presenting how the British present the trust and how they advise people to have the right taxation for trustor, beneficiaries, trustees, and protectors. So we all know that the trust is a way of managing assets. This is great. We all know that there are different types of trust, and we know that trust involves the settlor, the trustee, and the beneficiary. Something that we have to keep in mind, particularly for those living in continental Europe. The trustee is a person who manages the trust and has a legal interest in assets. So people in most cases forget this. When you are creating a trust, you are just abandoning your rights on your assets, and you really vest your assets into people that you don't know. They could be good people, they could be dangerous people, they can be crooks, whatever. But it is very important to keep in mind that you are just abandoning your rights on your property, and you ask someone to take care of. And the beneficiary, of course, is the person who benefits from the trust and has an equitable interest in the assets. So, no, what trusts are for? This is interesting because you will compare this list with the list of the reason to go to Belize. Trusts are set up for a number of reasons, including the control and protect assets, of course. Protection of assets is a key. when someone is too young to handle their affairs, when someone can handle their affairs because they are incapacitated, to pass on assets while you are still alive, to pass on assets when you will die. And of course, this is a British website, under the rule of inheritance if someone dies without a will in England and Wales. So all this is good. Seems to be comfortable. What the settlor does, he decides how the assets in a trust should be used. This is usually set out in a document called the trust deed. We all know what is the famous trust deed. We also know that sometimes a trust deed is not necessary because the trust can be set up just by a declaration made by the trustees, which is probably the worst form of trust that you can imagine. Sometimes the settlor can also benefit from the assets in a trust. This is called a settlor interested trust and has special tax rules. Okay? Type of trust, I will be quick on this. The bare trust, interest in possession, discretionary, accumulation trust. Well, and I'm saying because these were not on the website of the UK, you know, and many brilliant ideas. Sky is the limit. Indeed, there must be hundreds type of trust. Depending on your profile, your lawyer will probably create a tailor-made trust just for you, which is of course not good, because when it is tailor-made and the tailor is going away, you are lost with your suit. So each type of trust is taxed differently. Of course, it's a UK government website, so they will advise everybody to pay the right tax. I repeat, the trustees are the legal owners of the assets held in a trust, depending, of course, whether or not it is revocable or irrevocable, whatever. We will not go into the details of this. The role of the trustees is to deal with the assets according to the settlor wishes. This is fantastic. As set out in the trust deed or their will. Manage the trust on a day-to-day basis and pay any tax due, of course. Decide how to invest or use the trust assets, and if the trustees change, the trust can still continue, but there always has to be at least one trustee. So all this is good for people who don't know what to do. So they go on the website, they see all this, it seems to be a good plan. Beneficiaries, there might be more than one beneficiary, of course. The income they may benefit from, the beneficiaries may benefit from the income of a trust only, from renting, the capital only, or both. I'll give you an example that I'm recently faced. A settlor organized a trust so that the beneficiaries design should receive 25% of the income each. In the beneficiaries there was the spouse of the settlor, and of course his widow after a couple of years, and 3 children from a first marriage. The 3 children and the mother-in-law were not really friends. So what happened is that there was a clause in the regulation stating that the capital of the trust should be dedicated to the children of the children, not to the widow or to the surviving spouse. So this means that the 3 children had an interest of accumulating capital instead of having income, because the income should be shared 25% for the mother-in-law. So what they did, they made a deal with the trustee, and the trustee was a famous bank with having a branch in Liechtenstein. And the trustees agreed with 3 of the 4 beneficiaries, you know, to change the rules so that the asset would be contributed in kind to a Luxembourg company, so that the income generated by the asset would be stuck in the Luxembourg holding company, not distributing any income to the trust. So in fact, the surviving lady has been cheated by the children of her husband. You know, and now we are before the court and we are claiming 70 million euro of compensation. It will be a hard and long battle. Discretionary trust, so we know what it is. The trustee can make certain decisions about how to use the trust income and sometimes the capital, and depending on the trust deeds, they can decide on what gets paid out, which beneficiary, how often payments are made, any condition to impose. Discretionary trusts are sometimes set up to put assets aside for a future need or for beneficiaries who are not capable or responsible enough to deal with money themselves. Good. And the website of the UK government is saying, get help, okay. So you call the trust helpline, the probate and inheritance tax helpline, and if you need more help, you contact a solicitor or a tax advisor, and you can eventually talk to the HMM Revenue and Customs on your behalf if you give them the permission. And you can also get help from the Society of Trust and Estate Practitioner. All this is marvelous. So this is the end of the fantastic aspect of what a trust should be. Now let us have a look at the real world. I know it's unfortunately there are too many information, so I will read the more important one for you. Because this is a slide being part of another presentation, so I'll be very, very quick. Just to say that in Belize, if you look at the website of the law firms in Belize, what do they say? They say that this is the best place for asset protection against litigation, government seizures, lost privacy, pursuit by creditors, forced heirship, inheritance taxes, greedy wife, disruption management on death, high taxation, and economic instability and spendthrift beneficiaries. So you can see that in the reason for creating a trust in Belize, we have situation that a normal person is never facing. I mean, nobody has to protect its assets against pursuit by creditors or government seizures or litigation, whatever. Of course, in many cases, there is a tax aspect in creating a trust, even for continental people in Europe. The point is that they put the emphasis on confidentiality, anonymity, and tax planning. They say no registration of trust, no publication, trust deed not to be presented to any authority. And you know, the reason why to go to Belize, they are selling very well their advantages compared to the others. I will not go through the details of all this, but just to say, do you know that what's the capital of Belize is? It's Belmopan. It's a small city in the middle of nowhere, 15,000, 17,000 people, you know. This is the place where your assets will be managed. Of course, there is Belize City. Belize City is 57,000 people with the 6th highest rank of criminality in the world. So if you go well-dressed with jewels to Belize City, probably you go back home naked. So think about that. When in our job, in our regular job of investigator, when we see Belize, we know that there is a problem. Like it was the case 20 years ago with Luxembourg. Luxembourg changed quite a bit now. It's becoming more civilized. But Belize is just coming on stage. And probably there are good reasons for going there, but not for normal, ordinary people. The people who have something to hide probably should go to Belize. You know, Martin Kenny explained yesterday that Belize has a time limitation of 1 year. So this means that if you are defrauding someone, you know, probably the people should go quick to the court locally for having their assets retrieved. So everything is down for enabling people to hide their money. So now let's go on something that I'm facing today, and I would like really to draw your attention on this. This is a typical offshore trust built by a law firm in Panama. What do we see? We see a brave settler, the real one is Mr. X. At that time he was living in the UK, and of course he had a lot of UK friends and UK lawyers. He also had a friend living in Monaco, the same nationality, and they decided, because it was fashion at that time, to create a trust in Panama. So they contacted the UK lawyer of X and Y, contacted a Panamanian lawyer, which was in fact Shirley and Associates. I'm mentioning the name because at least, you know, they know that we know. And Shirley and Associates has proposed to this poor Mr. X, who was not poor and was probably not Father Christmas himself, you know. This guy was a very important businessman having a lot of problems and looking for protecting his assets from precisely what the Belize country is proposing today. So anyway, this Mr. X today is very old, he is Alzheimer. He cannot even remember who is his UK lawyers. He just remembers who are his children, but that's it. He cannot identify the documents, anything about his trust. So what did Shirley and Associates? They proposed a trustor being a BVI trust. So the trustor of the trust that I call the dark trust, it's not the real name of course, could be the bullshit trust as well. The dark trust, the settler, is a BVI trust. The trustees of the BVI trust name Financial Investment and Reinsurance Security Trust. These are the real names. was represented at the time of the trust deed by a certain Mr. Carrington working for the law firm. So the trustees that have been appointed upon recommendation of the law firm were two BVI companies, Asset Management Corporate Services and Strategic Management Corporate Services. These crazy names are fixed on purpose because it is almost impossible to remember the name of the trustees, particularly if you have 4 or 5 trusts like this. If you are changing asset by strategic and then by holding and then by I don't know what else, finally you are confusing the trustees with the protector and with the trust. And look at this. He is represented by Alexis Joseph, but the document was signed by Mrs. Casilda Watts. Casilda Watts has 406,080 mandates in Panama. So you see the type of trustee who will take care of your money. Then the second trustee is Strategic Management Corporate Services, represented by Mr. Hernandez, a former lawyer of OffshoreAlert and Associates. And Fernandez did not even sign the trust deed himself. It was signed by Mr. Alexis Joseph, another employee of the law firm. So finally, Hernandez has 8,851 mandates today in Panama. Again, this is a trustee who has no time, except signing documents. He has nothing else to do. He cannot take care of your assets. So what's happened is that the trust has been incorporated in '93. And at that time, the beneficiary was clearly Mr. X. And the protector was Mr. X. When Mr. X decided to leave UK and go back in his home country, he decided he was advised to change the trust into a discretionary trust. So no more beneficiaries. Protector has been changed and became another BVI company called Daisy Bloomfield Protectors Limited, represented by Mr. Joseph again. So Mr. Joseph is the protector and he's the trustee. The protector has the power to dismiss a trustee, has the power to request information and accounts from the trustees. So what can we do with a bullshit like this? When you need to have information about your assets, you are totally in the hands of the law firms. So what I did, I wrote to the senior officer of this law firm and I said, listen, I have a power of attorney, I have a general power of attorney of Mr. X in my favor. I would like to have a look on the records of the trust assets because we are considering changing a couple of things. And then I received this fantastic answer, saying hard time for investigators, hard time for me. What did he write? He said, dear sirs, I refer to your email dated December 15, 2014, and reiterate that Shirley & Associate has no relation with the dark trust, and therefore, we have no relevant document information on the dark trust, and if we had such information, which is not the case, we are unable to disclose them without a court order declared executable in Panama by the Supreme Court or an order channeled through a treaty of exchange of information or tax or other reason. The last line is fantastic. It appears that Mr. X should forward his complaint through the same medium he used to settle the dark trust. Is it not funny? I mean, this is a disaster. Because he's lying. He's telling stories because we know that the year before, Mr. Y, who is the friend living in Monaco, he received documents from the trustees, very confidential documents that has been passed to prosecutorial authorities in the home country of Mr. X. And the letter is saying, based on the instruction given by Mr. X never gave any instruction, we give to you, Mr. Y, all the documents that you require. So it is quite clear that Mr. Y is the man who has the hand on this trust. And in fact, he's the man that we're supposed to have taken the money. So what could we do with something like this? This trust has been fixed in Panama, but it is indicated in the trust deed that the Bahamas laws are applicable. Is it not nice? A trust created in Panama is 100% under Bahamas law. So what should I do? Should I go to Bahama to sue the law firm? And who? The BVI company being the trustees? So I am in the middle of nowhere. It's a lost cause. So this is definitely what will happen to you if you accept to enter this kind of bullshit trust. I'm sorry for the lawyers who do this kind of horrible things, but it should not be authorized. But people are stupid enough for accepting this and giving, we were talking about 70 million euro. 70 million euro disappeared. And I have to find the money. And I have the general power of attorney in my hand, signed before a notary, legalized, apostille, everything. And the lawyer is saying, oh, I don't know, but you should use the medium that has been used for creating the trust. This means that Mr. X has never met anyone from Panama, and Mr. X did not remember the name of his UK lawyer, because today he's sick. So, this is the first warning. Second case, Mrs. Agnelli. When Giovanni Agnelli died in 2003, he had only one surviving child, Margherita Agnelli, because her brother committed suicide 3 years before. It's a complicated family. So, when she went to the notary in 2003 to open the will, she has been received, I think, like 150 million euro really thrown on the table to her and say, okay, take this and be happy with that. So she was not that happy because she knew from her father that there were a couple of foundations in Liechtenstein. Among these, the Alkion Foundation, which has been set up in 2000, just 3 years before he died. So you see that the founder is Procurationanstalt in Vaduz, one of the black holes used by Mr. Batliner for creating, you know, endless number of trust everywhere. So we know that Procurationanstalt, in fact, was working for Mrs. Marella Caracciolo di Castagneto, the wife of Mr. Agnelli. We are talking about 700 million euro of assets here. His wife cannot read the balance sheet in the right sense. So she is officially the beneficial owner of this trust. And the council of the foundation, who do we have in the council? Angela Musleiner Batliner, the daughter of Batliner, Norbert Maxer, a lawyer, and Iwan Ackerman, the man who is managing all the accounting firms of the Batliner group. Obviously, this council of the foundation has nothing to do. They just have to execute instruction given by someone. But who? This is the point. Who is giving the instruction to these people? There must be a fiduciary contract, but with who? And who are the protectors? The protectors were Giovanni Agnelli signing a loan. So it was clear that when he was alive, he was the man deciding of what was happening there. And then we had three other names, Gabetti, Grandestevens, and Mr. Maron. Maron is the accountant. Gabetti was the close advisor of Mr. Agnelli, and Grandesteven was his lawyer. Gabetti, Grandestevens are close friends of Mr. Batliner, again. You know, so and when you see what the protectors can do, they're authorized to give compulsory instruction to the council for changing the bylaws, changing the domicile, liquidating the foundation, cancelling the regulation, managing the assets. The council of the foundation can design, can appoint the beneficiaries. And what has been sent to Margarita? She has been said, if you raise too many questions about the assets of this fund, you will lose your status of beneficiary. So that's what happened to her. So a few months after the death of Giovanni Agnelli, the lawyer of Margarita wrote a letter to Alkion Foundation at the Ohlerstrasse 74, which is the address of Batliner main offices at that time. So I will read quickly the letter. Standard letter when you know that you have a foundation somewhere and you are willing to know what's happening to this foundation. So they say, okay, this is to inform you that Mrs. de Palen is the name of his second husband, gave the mandate to represent her interest in connection with any matter and more particularly with her late father estate in the broadest meaning. She's a beneficiary of Alkion Foundation, and that explained the present letter. We hereby notify you of the following. Our client does not accept that Mr. Gabetti, Grandestevens, and Maron act as protectors of the foundation and give the foundation any instruction whatsoever. She will challenge anything that has been done or not done by the foundation unless it proven that it was in conformity with written instruction of her late father. Second, our client requires forthwith comprehensive explanation and documentation together with financial statements regarding the Alkion Foundation. Makes sense. Third, we hereby warn you to refrain from accepting any modification in the organization of the foundation and with respect to its asset, unless you have received prior written approval from Mrs. Balen. And last but not least, sound and responsible management of the foundation asset is responsibility of the foundation's board of directors. Your attention is drawn especially on the present material foreign exchange fluctuation. So it is a general letter. At that time, Margarita ignored the size of this foundation. It's only a few years later that a fortunate wind bring on the desk the financial statement of this foundation. And we discovered that there were more than 700 million of assets in this. So, the answer, look at this. It's signed by Procuration Anstalt, signed by Mr. Nobody, no signature. Dear Mr. Patry, we acknowledge receipt of your facts. We have not received instruction from your client, so in fact they made a mistake, it will be corrected. But we are talking about 700 million euro of assets, and this, they write this type of letter. Based on the elements available to ourselves and known by your client, her father was not the settler of the Alcyon Foundation, which is technically true. The settler of the foundation was Procuration Anstalt. And the foundation was not owned by him. Your client is a beneficiary, of course, and the board of foundation will respect the right as such beneficiary. So they corrected the letter 2 days after. They wrote another letter saying, okay, we have made a wrong statement. In fact, you have to read, really, we have no instruction to receive from your client. Next, what is not important. Okay, so this is briefly speaking. Liechtenstein is a special country. Liechtenstein, far before everybody understood that it was necessary to create vehicle tailor-made for each type of investor. So they have created what you have probably heard in your life, establishment, in fact, Anstalt, Trust, Registered Trust, Treuunternehmen, Treuhand Trust, and Stiftung Foundation. These are horrible names that probably you must have seen in the newspapers regularly. So I will not detail these slides because, again, it's part of another presentation, but just to say that there are slight differences between the different forms. And what is important is that trusts usually are not registered in Liechtenstein, so there is a secret list that have to be updated regularly of just the name of the trust, but it's not available to the public when it is a discretionary trust. Otherwise, if it is not a discretionary trust, normally you should file a minimum of information. But for all the other, they are supposed to be recorded somewhere in the trade register in Liechtenstein. So now, let's come to Liechtenstein in a more different way. I mean, there are 240 members of the Liechtenstein Institute of Professional Trustees. There are 240 firms rendering services for trust, accounting services, creating companies and all this thing. The biggest is Battliner Gasser, First Advisory Group, with more or less 230 people. Then you have other companies like Confida Treuhand, Jeeves Groups, Kaiser Partner, plus Presidential Anstalt. Kaiser Partner, for example, recently launched on its website an invitation to the US residents having problems in Switzerland to come and visit them, which is not bad, isn't it? So they have solution for the poor US citizens. That's great. So a few words about Dr. Herbert Battliner, and it will be detailed a little bit later. He's born in 28, it's some time ago. He has been awarded many honors, including the title of Gentiluomo di Santa Santità. This is absolutely exceptional honor to be named by the Pope as being a gentleman of His Holiness. Only a few have this honor. Unfortunately, most of these members of this club have problems with justice. So the Pope Francois, who is a good man, decided to stop this type of honor forever. So being a club of very old men, probably this order will disappear soon. So Battliner's name is associated with famous case, the Banesto case, a fraud, Löhner case, which is in fact a case in a German Democratic Republic with a lot of bribe for the Christian Democratic Party and Mr. Kohl. Everything created a lot of problem to Battliner, but he has never been sentenced to anything. And the thing important to understand who is Mr. Battliner, he purchased from the crown, from the royal family in Liechtenstein, which is the owner of LGT Bank, which is a very important bank. In fact, the most important one in Liechtenstein, having nice offices in Switzerland everywhere. So LGT had a fiduciary arm. I mean, it's the kind of company providing trust services and all the things. So LGT sold its branch called, LGT Treuhand AG to Battliner. So this means that the relationship between Battliner and the Crown Prince is very, very close. In fact, Battliner must be ranking number 2 in Liechtenstein in terms of importance, more or less. He's a very important man. So this is the guy. He's very old now. So again, this is just, this is an extract from the Pontifical Academy of Social Sciences that has welcomed Mr. Battliner as a member. Can you imagine? So I don't think it's interesting for you to read this because it's just a question of medals. We can see we have the Golden Medal of Salzburg, the Ring of Honor of Innsbruck, Knight Commander with Star of Silver String Order, Knight Grand Cross of the First Class of the Order. So this guy has so many medals that at the National Day he looks like a Russian general, on the red place near the Kremlin because it's all the medals on him. Okay, so here is the Battliner Empire. The couple is still there. Hundreds of companies in Panama. Large company in Liechtenstein is like HÜRNER Anstalt. HÜRNER Anstalt was the company used for paying kickbacks to bankers, in fact to directors of the UBS who were sending clients to Mr. Battliner. They were rewarded for the time of the foundation through money going through this foundation, and it was of course black money. This is the reason why, Switzerland is not that excited in creating problem to Mr. Battliner, because so many people have been paid, backstage for having contributed to the fortune of Mr. Battliner. So it's a whole system. It's almost impossible to break this. He's still there. So again, we could speak about each of these companies. That's no way. It's not interesting. So no, I will spend a little bit more time on this. These are my advice for you, your clients, whatever. So I know that this conference will be video available on the website of OffshoreAlert. So it is important, to draw the attention of the people who think about the trust. Thinking about the trust, is it a good idea? First, why, where did you really check a local solution or a solution in a normal country before going offshore? The day you go offshore, you must know that you are losing 80% of your rights as a human being, because you are jumping into another world, which is not your world. First, it's a common law system in general, and you are falling into legal systems that are closed and controlled by the law firm locally. And the law firm locally act closely with the government locally. So you have no chance, if you are running after money in one of these offshore centers, to recover it, unless it's really, really badly organized. So what type of trust? There are a lot of trust. With who? Is your home lawyer okay with trust? Does he understand what he is willing to do? Be sure that the lawyer is not rewarded backstage, because lawyers, when they bring someone to a law firm in one of these offshore centers, they are receiving money. Is the corresponding lawyer offshore appropriate? His reputation, did you check his reputation? The size of the practice? Is he part of a group? So you must know him and visit him. That's the reason why Mr. X has so many problems today in Panama. He never met the people in Panama. So the people in Panama do not know him. They just know the intermediary. That's the problem. So check the trustees. Please, no nominees, no empty companies owned by the lawyers. Applicable law, local laws for the trust, or even more exotic laws. Like, for example, a Panama trust with the Bahama laws. This is a problem. Protector must be someone who knows what's about. Neither a girlfriend nor a too close parent. So protector is not a joke. The protector has a real job to do. So it must be someone really good in checking what will happen with the trustees. Limit the scope of the assets management by the trustees. Be sure that at least once a year, a full report will be delivered. Inform the beneficiaries and think twice to who should be the beneficiaries. Never leave the trust sleeping too longer. This is the worst thing to do. Trustees being generally under the control of a foreign law firm, avoid the risk of having beneficiaries being told by the law firm that the trust does not exist under known name. This is happening, unfortunately, very often. When the beneficiaries go to the law firm will say, we don't know this trust. We are very sorry. Please go and visit other lawyers around me. Probably you will be more luck. You will have more luck. Why is this possible? Because in these offshore places, the trusts are not registered. So they can be changed by the law firm if the lawyer have decided to take the money. And the temptation is big in many cases. So do not have settlor, trustees, protector in 10 different jurisdictions. And again, who could change the trust deed basic rules? So you have to check about this. The settlor, problem is the choice of a nominee settlor. Prokurationanstalt, does it make sense to select someone like Prokurationanstalt as a settlor? Another trust? No. Don't give your money to another trust as a settlor. A professional truster linked to the lawyer? Not good. So what if settlor did not respect the home country inheritance laws, taxes, legal issues to come? Yes, this is the problem between the settlor and the beneficiaries. It's happened all the time. The settlor is happy. There is, of course, a long time before the tax authorities understand that they have been cheated by the settlor, and then the settlor is passing away, and then they fall on the shoulders of the beneficiaries. So, what if settlor is a tax evader or fraudster? Unfortunate beneficiaries. What if settlor used the trust for laundering monies coming from criminal activities? Again, same problem. Think twice about the links to keep between trustees and trustor, protectors, beneficiaries, the sham trust issue. This is, of course, an open route for plaintiffs who want to kill the trust construction. It's just to demonstrate that the trustor, the trustee, the beneficiaries are the same, and the trust construction is just a sham. So then you can obtain from the judge the cancellation, if I can say, of the trust, and then you can reach directly the people. So settlor must be seriously think about what will happen when he dies. It's not an option. Indeed, everybody is dying. So when the trustor is creating a monster like this, he must think about, you know, what will happen to the beneficiaries and to the beloved ones who will suddenly be in the hands of trustees abroad. Trustees, again, quickly. Who? A lawyer, an accountant, a professional advisor, a trustee company, a banker? You know, what to do? I mean, where will you give, where will you fix your money? You know, even bankers are probably not the best trustees, because we have a case now again in Liechtenstein. Unfortunately, we have many cases in Liechtenstein. But I mean, what's happening is that the banker managing the assets given to them by the subsidiary in the Bahamas companies being the trustee of the trust in Liechtenstein. The banker in Switzerland lost 75% of the money. It's not a fraud, it was just bad management and misunderstanding of what had to do with the money. So the beneficiary trust sued the trustee, and they lost the cause because they should have sued the Bahama company, not the banker in Geneva managing the assets. So all the time, legal problems. Income cannot be accumulated in sub-companies created by trustees. This is the worst thing. If the trustees have the possibility to create sub-companies, then you are lost, because they will put themselves as directors of the sub-companies, and they will do anything they want with your money. And not of course, stupidly. They will probably do a lot of the things that I'm mentioning in the frauds. They will buy assets at inflated prices from friends, parents, or companies owned by trustees. They will invest in assets recommended by bankers against discrete fees. They will produce zero or miserable recourse of transaction. They will blackmailing the beneficiaries because trust assets coming from tax evasion or whatever, if claims are large. They will abuse of laws for not doing, like in Guernsey, you know, this is crazy now. Trustees will not move even a pencil out of the trust if they don't have a legal opinion from lawyers they know. So if you want to sell one of your assets to a company you have in Luxembourg, belonging to you, so it's my left pocket to my right pocket, the trustee will say, ooh, we need a legal opinion about that. So at £600 an hour, you know, the contract will cost a couple of £1,000 for just moving a pencil. So we are facing that all the time now because trustees are afraid of being sued by the authorities or by the beneficiary. So we are now trapped in an infernal circle, you know. So trustees do follow instruction given by the few beneficiaries. This is also to be under control. So this to say, beneficiaries, okay, must be clearly identified and must be aware, should know each other for avoiding real wars. Why should they know each other? Because if they don't know each other, probably the trustee, as it happens many times in Liechtenstein, will say, oh yes, you are a trustee, but where are the others? But I don't know the others. But you know, the trust deed is saying that I cannot give information if all the trustees are not around the table. So this means that the trustee will sit on the money for a couple of years before the poor beneficiary is aware of who are the other beneficiaries. So if you are willing to give your money to a mistress and to your children, create two different trusts. Don't put everyone in the same trust. So, could disagree with the settler choice, of course, problems to come, could request full knowledge of what has been done with trust assets before the settler passed away, and so forth. Could lose the statute of beneficiaries, tax issues to consider, and so forth, and so forth. So the protector, same things, you know, I'll just to make it short. So finally, my opinion is, do not go offshore when home is so good. Think about the beneficiaries. You are a genius, but they are not. So, I mean, really, my advice, and this is my daily practice as a financial investigator, think twice before going offshore with your trust ID, because there are other solutions, okay? We can propose good solution in European countries, for example, by just, you know, bringing your assets to a company. And then, you know, you are the shareholder, you can appoint directors. It's easy to check all this. I mean, and this is under supervision of real legal system, where people do not have to render service to each other all the time. So no, this is the idea, you know, I had this idea. So I was first thinking calling it the trust bank. That's not a good idea to call a trust bank, you know, because banks have no good reputation today. So I'm saying the International Trust Federation. The idea is the following. There should be somewhere in a country where secrecy would be possible, an international organization owned by members being participant to the system and signing the chart. One member, one vote. Managed by a board of independent persons elected by the members for 2 years. Financed by a really modest contribution of trustees out of trust funds. Receiving this International Trust Federation should receive from all over the world a certified copy of the original trust deed, a certified copy of the letter of wishes, otherwise the letter of wishes could disappear, a certified copy of the list of beneficiaries, all the details, the financial statement of each year, at least 6 months after each year, and the identity of the settler, plus amendments if any. So this international trust would deliver a registration number for each trust participating. And if your trustee do not give you a registration number, don't go in this system. This means that you will not be protected. So this organization could solve dispute on the discrete basis between trustees, beneficiaries, protector, and settler. So this is an idea, I mean something that is possible, it makes sense. This would give some substance to offshore trust, but if this organization does not exist, so it's better not to go offshore for a trust ID. So, no, I'm right on time. Sorry, I've been a little bit quick, but you know, 45 minutes for talking about all this is not easy. But if you want to have a few of these slides, come back after the session to me and I will send it by email. So now I would like to introduce briefly Mr. Klaus Lins. He's probably the first European whistleblower and then the very first victim of the system. You know, it's dating 1994 and 97. So here is his story and here is what happened. So he will explain. I'm sorry for his English. You know, he's German speaking. He's not really fluent, but he made a lot of efforts for preparing this presentation. So he will read his text about his story and then we will see the film, which is a short one, just 20 minutes. Thank you very much.
Good morning, ladies and gentlemen. My name is Klaus Lins. I'm from Austria. I just live 1 mile from the border to Liechtenstein. I'm 58 years old. As Mark said before, also a journalist told me a few years ago, I was the first whistleblower in Europe. I'm not too sure I'm a lucky one. Maybe I don't know. What I know is that I have not been able to continue my work with and for a man who was defrauding his clients. Sorry. I don't care too much about this, but he also defrauded many beneficiaries, such as social services, on a large scale. My idea was to stop his bad practices and not to make any money by selling confidential information to somebody and someone. But Liner made a huge fortune on 30 years and not with $2,000 of fees per foundation. Here is my story. I worked from January 1st, 1985 till February 1995, officially till May 31, 1995, in the office of the famous Dr. Herbert Liner. When I speak now from Dr. Herbert Liner, I say DDR or DDR. Yesterday, David Marshall laughing because Liner, and it's a truth, he always want say doctor, not only Dr. Liner, Dr. Liner. And if he was absent in the office, we only speak from DDR. Also, all citizens from Liechtenstein, if you ask them, you know Liner, they ask which Liner. Have too many names, also have flowers with the name Liner. But you say DDR, say everybody know him. This is famous Dr. Liner. DDR also the short name for the German Democratic Republic, very democratic, same Liner, and you can think what you want. More precisely, I was employed by a company named Prokurationsanstalt, you see before by Mark, one of the main companies of DDR, as it has been explained by me, by my co-speaker before. My job was to install an IBM computer system, first system 34, later system 36, and then application system 400, and to organize the maintenance of the software. I had access to all the data. I was the only one having the administrator and security officer password. Previous I worked in this office, DDR had no computer at all. He makes everything on the paper. The first few years I was very proud to work in the office of DDR, and I was also proud of him. Even he was a very choleric boss and absolutely a patriarch. For example, the office boy, we had a boy bringing coffee and such things, had to report to DDR how many cups of coffees every secretary, everyone is drinking every day. But at the same time, in every office from the secretaries, there are paintings from Picasso, Monet, Van Gogh, and so on, and worth millions. He have one sculpture before his house from Henry Moore from America, X tons. I think this transport from America costs more than the same time I build a house, same, but only the transport, not the sculpture. One day, I think in the year 1992 or early 93, The personal secretary of DDR had problems with her printer. I not remember exactly what she have. Maybe toner was empty, but anyway. I had to fix it. When I completed my work, the secretary printed out some document for looking everything is now okay. I not think about this. I take this paper to my office in my room and take it down, and I forget these things. Sometime later, maybe 1 week, I not remember, I clear my desk and I read this forgotten document she print out. And what I see, I can't believe.
It's okay, it's okay.
I not trust my eyes. In this document, there are special. Sorry, no. Sorry, no. Yes, I clean my desk and this day when the secretary had this problem, an older lady from Germany come to the office of DDR, and she asked for details for a specific foundation. She knows the name of the foundation, and she knows this foundation must be in the office of DDR. To take it short, what was the content of the document that DDR dictated to his personal secretary she printed out? This was a confidential note to all the members of the advisory board in the office of Dr. Berliner. Quote, in the matter of this foundation, I say now XY, today Miss sowieso from Germany visit our office and ask for XY Foundation. If I, Dr. Berliner, would not have been in the office and Miss from city in Germany would have called our office later, or she would have visited us again, I told her we do not know anything about the foundation, go around and visit maybe other accounting firms, and this foundation never had a domicile in our office. Finish. When I read this, I ask and talking to myself, why he writes this? For what? For what? If this foundation not in our office, for what he write? For what? I not understand. I go to the computer, I type in the name of this foundation, and nothing, we not have. But then I think for what he writes is. Days later, I have self-doubt, let me not sleep because I not understand. I installed an older backup of the system from diskette, from the backup. I searched again, and bingo, I had the name. I had all documents, everything to this foundation, statutes, rules, correspondence with bank, with the father of this lady, everything. And of course, she also was a beneficiary of this foundation. Note, this time, this is 1992, 1993, you couldn't search same today with full text. You only could search for an index you have to make yourself. And for this, I couldn't type in the name of this lady and search in the text. It's impossible. What happened? DDR, he changed after the death from the father of this lady, he changed the name of the foundation. He not make a new name of foundation, he overwrites the old name. You can make also a new one, you but he overwrite the old name, and nobody except me would be able to find out the old name, because I have the old backup from the files, but a secretary cannot because it was override. For example, if you change my name in your mobile phone to Hans, and you never, and you search for Klaus, you never will find, but you know Hans is Klaus. But if a foreign go look your mobile phone and he type in Klaus, he not will find me. You know my name Hans, but same Klaus. So far, how many beneficiaries never heard about the foundation built by their parents or of course other founders, settler, friends, uncle or somebody, and who sees these assets? Nobody knows. Of course, I was very disappointed, devastated, shocked. Then I cannot say how long, but many months surely. I just went to work like a robot. I'm very disappointed and not understand the whole world. And I started to copy the files to floppy disk. I don't know why, but I do. But this time we had 8-inch diskette, very big diskette, and for all documents I need about 80 pieces. This I cannot take out of the office in my trouser package. Later in a Spiegel, it's a newspaper, Spiegel, everybody know, they wrote that I stole a CD. In 1994, nobody had CDs, only CD-ROM, read-only memory, you know, anyway, and you cannot back up to this medium. Yes, also when I have to go to court, this 2 years later, 1999, Dr. Berliner also tell them that I stole a CD. He lie. I cannot stole a CD, cannot make on this computer. In fact, I purchased the tape with my money, where I steal the data. And the same time, I never hear the word whistleblower at all. I don't know the word whistleblower. I never hear. And in 10 years, I never stole in the office of DDR something physical, not even one pencil, or I drank never more than 1 cup of coffee one day. At the end of 1993, we had also an additional tape drive for small tapes, very small. I ordered this with the agreement of DDR, but I think if he would know for what I need this, he not will give me his approval. Now I need only one small tape to copy everything on the computer. But I could not do something with this tape, just nothing. I needed the same IBM computer application system 400 to read this tape, and this was impossible for me. This cost about 500,000 Swiss francs, but I accumulated these tapes in my home. I make periodically, I make a backup and take home, just in case maybe someday it's good. In the meantime, I tried to find out more about the foundation of the German lady, and I had good luck. I have some time to act in place the man who was in charge of the archive where all the bank statements were stored, and I could copy everything, but on paper, this in the cellar, and sometimes this man had holiday or something. I act in place for him. Yes, in this time also I was sitting in the cellar and had to do nothing, and I looked in other folders. I don't know, it was fortune or good luck, but I had one dossier in my hand where the children village was amongst other beneficiaries, beneficiary of a foundation. The founder died about 10 years before, and this children village had still received nothing, absolutely nothing, not one Swiss franc. This foundation is also part of the documentary film After from Swiss TV. Hans-Jürg Zumstein is the author, you see in a few minutes. I was very disappointed and I was angry. I cannot describe my mood I had. I started to drink to forget, not beer, also whiskey, probably not the best. I was out of money every day, but I want to work also every day. In September 1994, we had a company outing to Vienna for 3 days. I feared this trip. We make this every 5 years. I not like it. The whole year to go there, but it was obligation to go with the family of DDR. On this event, I drink too much, and I asked 3 of the consultants of our office, but not on the same time, what happened with the money of a foundation or trust if nobody asked for the money? What happened with this? I knew that 90% of the beneficiaries and 99.9% of the beneficiaries of social services, just children villages, hospitals, churches, universities, Red Cross, and so forth, they did not know that they are the beneficiaries. And they could expect incomes. They don't know. Okay, what the consultants tell me, you are too nosy. That is what they say, nothing else, nothing. And this nothing was for me the sentence of death in the office, which I know it. I think they not like employees who raise too many questions. 1 week later, I had to move in another room. Before I have my room just beside the computer, I have to go down. Nobody tell me why. I had to make my work, but there nobody else could do my job. I'm alone. I have still alone the security password and only me. But always a security man go on my side when I go to the computer room, but 3 weeks before I copy anyway everything. In February 1995, DDR terminated my job without notice. He just kicked me out. 2 men come and say, finish, take out. In 1995, I contacted a lady in Germany. We had a meeting in Bregenz, is near my home on the Lake of Constance. And I gave her all the documents concerning her father's foundation. She's still fighting with DDR. She asked for official judication assistance in Liechtenstein, but Liechtenstein not handled till today. The former boss of the competent authority in the government of Liechtenstein changed after 20 years working in the government, and they have good salary. What do you think to whom he changed? To DDR. After 20 years, he boss in the competent authority. Also, Mr. Zumstein, he make film, he make an interview with this lady, but you cannot see on the film, but he make an interview, and but this lady say not show. Okay, now the children of DDR have shares of his company, but of course he is keeping the majority of the voting rights. Okay, I have not been alone, have troubles. My brother is a painter and decorator. He worked many years, not for, but in the houses of Berliner. He is a specialist, and he painted the villa and the other buildings he have. When this happened with me, he also kicked him out and make troubles in his company where my brother worked. But 2 years later, DDR asked my brother again to do paintings in his villa because he wants silk wallpaper and nobody in Liechtenstein can make, just my brother can, and now he works, he happy, and it's okay. In 1996, I look to disclose this case with the children village, and I met people of the magazine The Spiegel in Germany. I worked more than 1 year with 3 journalists of the magazine, and I had the hope they would only open, but they cheated me. I'm too stupid, and they cheated me. They were only interested in German politicians who had money hidden DDR structure, and they did not check this. I think to the good of the people. But this gives me the chance to copy all my files and my data from the tape to CD-ROM. Then I have all my data on CD-ROM. This is the first time, but this in the year 1996. At the end of 1997, Spiegel wrote an article of 18 pages, one magazine, about money laundering in Liechtenstein, with my files, of course. And the same day as the printed magazine come out, DDR lodged a criminal claim against me before the court for blackmail. 1996, this is 2 years later, when the magazine come, he tells the court I make blackmail. I never spoke, I never wrote. Since he kicked me out, I no have contact, nothing. And of course, never I make blackmail. At the end of 1998, I had 4 lawsuits. In the first one, they discharged me. In the second and third case, they convicted me to 2 weeks contingently only for steal the data. 2 weeks, but it's okay. All in Velker, my hometown. The fourth one took place in Innsbruck. This is another country, higher court. And the justice, a personal friend of DDR, was a justice. They studied together, the same old, in the same university, the same time, and they are in the same fraternity. And he convicted me. This court, I think, I stay in there 3 minutes or 4 minutes. He convicted me to 30 months of prison unconditionally, and I had to pay about euro 150,000 for fine for having damaged the reputation of the office of DDR. Okay, disaster for me. Nobody helped me. In 1999, I went from May till December to prison. Then a former justice from Feldkirch, his name Peter Mück, and a psychiatric doctor named Albert Link from Feldkirch. They helped me very much, and the Justice Peter Mück took me out after 6 months. How he do, I don't know, but I come free after 6 months. But anyways, this prison period that has been a very good withdrawal treatment from whiskey. In the year 2001, I had to sell my house to pay the fine for DDR, of course, 150,000 I not have. And then, a little bit later, my wife divorced from me. The only real, very good, lucky thing in this time when she divorced from me. Sure, I never sold any information to anyone during all these years. The CD, maybe you hear, has passed by the journalist of the Spiegel to the German tax authorities. The German tax authorities passed the information to the Swiss tax authorities, and the authorities recovered millions. Alone, I think German, they write in newspaper, come TV, 500 million euro, Swiss about 200. It's interesting, Swiss have more cases than whole Germany, and I think the data is 1 to 10. I have 10 times more data from Germany than from Swiss, but Swiss make more money in the thing than Germany. Okay, now. Okay, then I have one thing. Someone mentored me to go to the IRS. The IRS makes a whistleblower program, and I started filing in forms, but I have no return. I see here two ladies from IRS, and of course, then read. This would be a known story. I could speak about 3 hours about this. The lady Liz behind, I think she tell yesterday, they change many things. I not see change anything, but this is another thing.
Okay, go.
Okay, this everything, and now you can see the film. Thank you very much, and sorry my bad English.
Okay, here we are. It's 20 minutes.
Das ist Klaus Lins. Er hat Tausende von Kundendaten gestohlen. Seine Daten führten zu Hunderten von Steuerstrafverfahren. Das Jubiläumsbuch der Treuhandkanzlei, in der er die Daten gestohlen hat. Die Kanzlei habe gemeinnützige Organisationen geprellt, behauptet Ritz. Sie habe Stiftungen verschwinden lassen. Deshalb habe er die Daten gestohlen.
Dann gab es die Stiftung plötzlich nicht mehr im Computer. Es wurde nicht der alte Name, neuer Name, sondern der alte Name wurde überschrieben, und durch das war die alte Stiftung natürlich absolut unbekannt. Und dann bin ich auf eben solche Stiftungen gestoßen, wo soziale Einrichtungen wie Kinderdörfer und so weiter begünstigt waren, wo genau dasselbe passiert ist.
Die unglaubliche Geschichte beginnt in Liechtenstein in Vaduz. Klaus Lins arbeitet in der renommierten Treuhandkanzlei Dr. Badliner. Professor Dr. Herbert Badliner, eine Koryphäe in Liechtenstein, gilt als Pionier der sogenannten anonymen Stiftungen. Diese funktionieren so. Den Stiftungsnamen kennen nur Badliner und der Stifter. Nur sie wissen, wo das Geld liegt. Viele Millionäre nutzten jahrelang diese Konstruktion, um Geld vor dem Fiskus zu verstecken.
Ich habe nichts anderes getan, als einfach die legalen Möglichkeiten, die nunmehr das Stiftungsrecht ermöglicht hat, das auszunützen und somit auch als Vertrauensanwalt verschiedener Institutionen geschaffen, die Stiftungen zu errichten. ich möchte bewusst sagen, ich habe nur legal gehandelt, absolut nach liechtensteinischem Recht, aufgrund der gesetzlichen Möglichkeiten aus dem Jahre 1926.
Wenn der Stifter stirbt, weiß meist nur Badliner, was mit dem Geld geschehen soll. Jahrelang ist Dr. Badliner erfolgreich und wird sagenhaft reich. Er sammelt Kunstwerke, die er großzügig für das Publikum zugänglich macht. Einziger Tiefpunkt in seiner Karriere, der Datendiebstahl, der Beginn der unglaublichen Geschichte.
Sie müssen sich vorstellen, ein renommierter Anwalt und Treuhänder wird nach fast 40-jähriger Berufstätigkeit konfrontiert mit einem derartigen Vertrauensbruch. Können Sie sich ja vorstellen, was das allgemein bedeutet hat. Für mich war das, also nicht nur für das Geschäft, sondern für mich persönlich war das ein unwahrscheinlicher Stopp. Sondern meine Prinzipien der Seriosität und vor allem auch der Diskretion, das von einem Kadermitglied verletzt zu wissen, hat mich persönlich unwahrscheinlich hergenommen.
Das ehemalige Kadermitglied, der Informatiker Klaus Lins. Heute, über 10 Jahre später, lebt er in dieser einfachen Wohnung.
Eine kleine Küche und da in meinem Wohnzimmer.
Lins ist überzeugt, einige Stifter wollten, dass ihr Geld nach dem Tod an gemeinnützige Organisationen übertragen werde. Badliner habe das nicht gemacht, deshalb habe er Lins die Daten gestohlen.
Dann habe ich einen Spiegel kontaktiert und habe denen gesagt, okay, ich habe diese Daten, um mein Motiv natürlich auch, oder? Ich möchte, dass die Kinderdörfer und ihr Geld bekommen. Und dann waren auf einmal 3 Journalisten und sogar beim Stefan Aust in der Chefredaktion war er persönlich. Der wollte mich einfach kennenlernen, gesprochen haben wir eigentlich nichts, aber er wollte mich kennenlernen.
Felix Kurz, damals Spiegelredakteur, erhält von Lins einen Teil der Daten. Doch dann nimmt die Geschichte einen anderen Verlauf, als Lins will.
Da haben wir eine Arbeitsgruppe im Spiegel gebildet, da waren mehrere Redakteure beteiligt und dann sind wir halt doch auf den einen oder anderen interessanten Namen gestoßen. Wir haben auch herausbekommen, wie Herr Badliner zu Herrn Kohl stand, dem damaligen Bundeskanzler, und wir haben auch in Erfahrung bringen können, dass eine Menge prominenter Leute aus aller Herrenländer, übrigens nicht nur aus Deutschland, dass die dort Stiftungen hatten mit teilweise sehr, sehr erheblichen Beträgen.
Der Spiegelartikel löst in Liechtenstein ein politisches Erdbeben aus.
Dieser Artikel hat, glaube ich, für viele in der Öffentlichkeit mal deutlich gemacht, in welcher Dimension Steuern in Deutschland hinterzogen werden. Und auch mit welcher Dreistigkeit teilweise. Und auch mit welcher Raffinesse. Das hat man vorher nicht so gekannt.
Klaus Lins wird kurz danach verhaftet und in seinem Wohnort in Österreich wegen Erpressung zu 30 Monaten Haft verurteilt. 10 davon unbedingt.
So ja, das ist das Landesgericht Feldkirch. Da habe ich meine Prozess gehabt, 3 in der Zahl. Und da im hinteren Gebäude, da bin ich auch in der Haft gesessen. 3-4 Tage und dann bin ich nach Dannenberg gekommen und habe dort meine restlichen Monate abgesessen.
Und gleichzeitig muss er eine hohe Geldstrafe an Dr. Badliner bezahlen. Lins ist nach der Haftentlassung mittellos. Er verkauft jetzt die Daten der Deutschen Illustrierten Stern. Und vom Stern gelangt die Daten-CD zur deutschen Steuerbehörde. Der zweite Teil dieser unglaublichen Geschichte beginnt. Reinhard Kilmer ist einer der Steuerfahnder.
Die CD Badliner ist Anfang 2000 im Briefkasten der Staatsanwaltschaft Bochum gelandet und nachdem man zunächst das Datenmaterial gesichtet hat, wurde ziemlich schnell klar, dass es sich hier um Material handelt, das für die Ermittlungsdienste von ganz erheblicher Bedeutung ist. Das waren sehr lukrative Fälle, für den Fiskus sehr lukrative Fälle. Im Grunde genommen kann man sagen, das ist für die Finanzverwaltung wie ein Sechser im Lotto.
Zuerst läuft alles gut. In der Staatsanwaltschaft Bochum stapeln sich die Akten. Die leitende Staatsanwältin Margret Lichtenhagen greift zu harten Methoden.
Viele Stifter haben auch zunächst die Existenz dieser Stiftung bestritten. Das hat dann dazu geführt, dass es zu Untersuchungshaft kam, weil auch Flucht- und Verdunklungsgefahr bestand. Und in der Untersuchungshaft ist allen Stiftern dann doch wieder eingefallen, dass es eben doch eine Stiftung gibt. Aber einige haben sich schon sehr schwer getan, sich daran zu erinnern.
Trotzdem sind die Ergebnisse bescheiden. Die unglaubliche Geschichte setzt sich fort. Doch vorerst erreicht die Daten-CD die Schweiz. Das dritte Kapitel beginnt. Die Daten lagern auch heute im Archiv der eidgenössischen Steuerverwaltung. Gestohlene Kundendaten in der Schweiz sind Ermittlungen damit verpönt.
Das ist die CD, die wir im Februar 2002 anonym per Post zugestellt bekommen haben. Und unsere Ermittler haben gesehen, dass da steuerlich relevante Daten drauf sind. Dass es auch Schweizer hat, die offenbar Steuerdelikte begangen haben.
Und so schickt die eidgenössische Steuerverwaltung die Daten einfach an die kantonalen Steuerfahndungen weiter. Die Kantone ermitteln jetzt mit gestohlenen Kundendaten, obwohl die offizielle Schweiz so tut, als sei das nicht erlaubt. Das schlitzohrige Vorgehen hat das Bundesgericht genehmigt.
Das war in dem Sinne ein bisschen der Einstiegsfall vom Bundesgericht. Das Bundesgericht nachher gesagt hat, wohl, die Daten dürfen wir verwenden, weil wir haben die von der eidgenössischen Steuerverwaltung bekommen. Und insofern ist das für uns unproblematisch gewesen, mit diesen Informationen zu arbeiten. Ob schon es ursprünglich gestohlene Daten sind.
Auch die Schweiz ermittelt also mit Kundendaten, die im Ausland gestohlen wurden. Wer es nicht glaubt, hier ist der Beweis.
Wir haben gewusst, dass es Daten sind aus dem Treuhandbüro von Dr. Battliner. Für uns war aber nicht erwiesen, dass die gestohlen waren.
Was für eine andere Möglichkeit hat es? Der Battliner hat es ja sicher nicht geschickt.
Das können wir nicht wissen. Das ist bei uns oft so in der Praxis, wenn wir anonyme Informationen bekommen, dann sind die Informationen sehr knapp. Und aufgrund von diesen spärlichen Informationen kann man auch nicht nachvollziehen, ob das gestohlen worden ist oder nicht.
Aber hier ist das ist ja ein umfangreicher Datensatz. Es sind Tausende von Daten, die da drauf sind.
Der Einsatz der gestohlenen Kundendaten ist für die Schweiz ein voller Erfolg. 180 Steuerverfahren leitet sie ein. Anders in Deutschland. Untersuchungsausschuss des Parlaments des Bundeslandes Hessen. Die gute Laune täuscht. Es geht um ein ernstes Thema, denn Deutschland führte mit der gleichen CD nur 160 Verfahren durch, 20 weniger als die Schweiz, obwohl in Deutschland mutmaßlich mehr Steuersünder leben. Kompetenzkonflikte zwischen verschiedenen Ämtern seien die Ursache, sagt die regierende CDU. Nein, politische Behinderung, behauptet dieser Mann, Frank Wehrheim. Wehrheim war jahrelang Steuerfahnder in Frankfurt. Heute will er vor dem Untersuchungsausschuss erklären, wie sein Team behindert wurde.
Er hat nervös aufgeregt, ist so angespannt, respektvoll der Situation, ja, aber in dem Sinn so ähnlich wie früher, wenn es mal eine Gerichtsverhandlung aussagen musste.
Wir sind in 2001 nach Bochum gefahren, nachdem wir von der Badliner CD erfahren hatten.
Das war meine Person mit zwei Kollegen.
Dann passierte, als wir die Vorermittlungen aufnehmen wollten, etwas Eigenartiges. Der damalige Hauptsachgebietsleiter der Steuerfahndung sprach mich an und sagte, diese Ermittlungen machen nicht Sie.
Die Steuerfahnder werden zunächst versetzt. Die Geschichte um die Daten-CD kippt ins Absurde.
Später habe ich dann erfahren, dass die Staatsanwaltschaft Bochum die Fälle, die uns übergeben wurden, in Frankfurt nicht bearbeitet wurden. Die Fälle waren über einen sehr langen Zeitraum schlichtweg unbearbeitet in Aktenschränken abgelegt.
Mir wurde damals das Heft der Handlung entzogen, aber sie wurden auf meinen Namen stehen gelassen und sie wurden nie bearbeitet.
Sie sind ja auch in die Vorstandsetagen der Banken reinmarschiert. Die haben sich auch nicht zurückgehalten, wenn es um andere Prominente ging, auch wenn es darum ging, auch CDU-Politiker zum Beispiel zur Rechenschaft zu ziehen. Da gab es ja auch eine Reihe Fälle und dass sich dann das Imperium, sage ich mal, wehrt, wenn es ertappt wird, erwischt wird, das ist eigentlich klar. Nur, dass es auch mit gewissen Maßnahmen durchkommt, ist eigentlich in einer Demokratie wie in unserer überhaupt nicht erklärbar.
Steuerfahnder Rudolf Schmenger ist fassungslos über seine Entmachtung. Er wehrt sich vehement.
Das hat dazu geführt, dass man dann im Jahre 2006 über ein Gutachten hat man mich psychiatrisiert. Und über dieses Gutachten gegen meinen ausdrücklichen Willen in den Ruhestand versetzt zum 01.01.2007.
Wehrheim und Schmenger sind seither nicht mehr Steuerfahnder. Auch darum geht es im Untersuchungsausschuss. Zwangspsychiatrisierung von Steuerfahndern mit falschen Gutachten. Der Autor des Gutachtens ist inzwischen gerichtlich verurteilt. Doch wie konnte es so weit kommen? Es ist bereits der zweite Ausschuss und die Frage ist immer noch nicht beantwortet.
Liebe Kolleginnen und Kollegen, dann darf ich die Sitzung eröffnen. Ich darf jetzt in diesem Moment die ton- und bildgebende Presse bitten, ihre Aufnahmen einzustellen und den Saal zu verlassen. Gilt auch für Sie.
Die Verantwortlichen der regierenden Parteien CDU und FDP wollen nicht Stellung nehmen. Die Geschichte ist so unglaublich, dass selbst der Mann, der sich jahrelang damit befasste, ratlos ist.
Also wenn in dem Fall ist es ja so gewesen, dass eben die CDU-FDP-Regierung das zugelassen hat, dass diese 4 Steuerfahnder, aber auch andere, die ganze Steuerfahndung letzten Endes in Frankfurt wurde ja zerschlagen. Und 4 Steuerfahnder wurden ja sogar mit psychiatrischen Gefälligkeitsgutachten mehr oder weniger für verrückt erklärt, für dienstunfähig erklärt und wurden dann in den Ruhestand versetzt. Sowas stellt man sich eigentlich nur vor in totalitären Staaten. Und es ist leider auch für mich überhaupt nicht nachvollziehbar, warum die Opposition da nicht also wirklich Alarm schlägt, warum das nicht größere Auswirkungen hatte in Deutschland. Also da bin ich ein Stück weit auch ratlos.
Zurück zu Klaus Lins. Jahrelang hat er geschwiegen, heute spricht er erstmals. Er wolle nochmals versuchen, gemeinnützigen Organisationen zu Geld zu verhelfen.
Ich wollte die Sachen aufdecken, habe diese Daten dem Spiegel übergeben und der hat dann aber ganz eine andere Geschichte draus gemacht. Er hat wegen Steuerhinterziehung von Politikern und ja, anderen Leute eine Story gemacht, aber nicht meine Motivation, dass endlich die Kinderdörfer und sozialen Einrichtungen zu ihrem Geld kommen. Ich hoffe, dass der Beitrag dazu beiträgt, die Sachen, die Machenschaften der Treuhänder aufzudecken. Ich weiß auch nicht, wie man das besser kontrollieren könnte, aber die können mit dem Geld aus einer Stiftung einfach machen und walten, wie sie wollen. Sobald der Stifter stirbt, weiß das alleine der Dr. Madliner, also der Treuhänder. Wenn sie nichts in der Hand haben, dann werden sie niemals etwas von diesem Geld sehen. Vor allem natürlich die sozialen Einrichtungen, die natürlich gar nicht wissen, dass sie Geld bekommen würden.
Professor Dr. Herbert Madliner, ein Ehrenmann. Er wird regelmäßig mit Preisen ausgezeichnet. Gerade er soll unvorstellbar.
Sie hätten das Geld, das Ihnen Stifter anvertraut hätten, teilweise nicht an Begünstigte ausbezahlt.
Das ist unwahrscheinlich perfid. Auch wenn man mich kennt, ich glaube, das ist so etwas Perfides, dass ich auf das fast nicht näher eingehen will, weil es sind ja diesbezüglich keine konkreten Vorwürfe für den Erfolg, absolut nicht. Also.
Bleibt der Fall Buwert, Hotel Borolac, Zürich. Dr. Badliner trifft sich hier mit der halbblinden Witwe Buvert, einer reichen Klientin.
Und das hat nichts mit dem Datenklau zu tun, sondern es war ein Fall, ein sehr freundschaftliches, ein Verhältnis mit der Dame Buvert, und sie hat in großzügiger Weise, beziehungsweise meiner Frau, eine großzügige Schenkung gemacht.
Aufnahme der Witwe aus dem Jahre 2004. Ihr verstorbener Ehemann war der CDU-Spendensammler Hans Buvert. Auch er legte seinerzeit sein Vermögen in einer anonymen Stiftung bei Badliner an. Nach dem Datenklau durch Klaus Lins ermittelt die Steuerfahnder auch gegen die Stiftung Alma Mater und deren Begünstigte Christa Buvert. Sie engagiert den Anwalt Jürgen Wagner. Schockiert realisiert er, dass sich ihr Vermögen drastisch reduziert hat. Er beginnt zu recherchieren.
Wir haben zunächst einen Vertrag handschriftlich gefunden, dass die Frau Buvert den Herrn Badliner 10 Millionen geschenkt haben soll. Und das war genau nach dieser Zeit, als bereits ihr Name im Spiegel aufgetaucht ist, Ende 1997, im Zusammenhang mit dem damaligen Datenklau bei Herrn Badliner.
Unfassbar. In Borolak soll die Witwe Buvert angeblich über die Hälfte ihres Vermögens Badliner verschenkt haben? Während eines Mittagessens?
Dort hat, so die Aussage seiner Frau, er seiner Gattin entsprechend einen Schenkungsvertrag diktiert. Sie hat ihn handschriftlich abgeschrieben und hat dann eine Zeile freigelassen, in der unsere Mandantin, die Frau Buvert, eben entsprechend eingetragen hat mit zittriger Handschrift, weil sie auch praktisch nichts mehr gesehen hat. Genau diese Zeile hat sie in den Betrag eingesetzt und hat hingeschrieben 10 Millionen Schweizer Franken und hat ihm damit, wenn das eine Schenkung gewesen sein soll, ihm 10 Millionen vermacht, die dann gleich am nächsten Tag mittels 3 Schecks in sein Vermögen flossen.
10 Millionen Schweizer Franken. Und kurz danach lässt er sich nochmals 1,8 Millionen Franken schenken.
So etwas haben wir noch nie erlebt. Vielleicht mal mehr oder minder große, kleine Gelegenheitsschenkungen, aber nicht für, wie es hier heißt, eine persönliche Schenkung für seine Dienste. Also die Dienste müssen natürlich gewaltig sein, wenn man 10 Millionen bekommt als normale Schenkung, zumal Interessenskonflikte vorliegen und ein Treuhänder darf das einfach nicht annehmen.
Nachdem hier von bestimmter Seite dieses Geschenk als anrüchig beurteilt wurde, habe ich freiwillig diese ganze Schenkung zurücküberwiesen.
Er hat wortlos erstmal 10 Millionen zurückbezahlt. Wir haben uns später dann lange streiten müssen um die anderen 1,8 Millionen plus die entsprechenden Zinsen, also letztlich um knapp 3 Millionen.
Und das hat er schlussendlich alles zurückzahlen müssen?
Müssen, ja. Also nach entsprechenden 8 Verfahrensgänge, also 4 Prozesse zur Einsetzung überhaupt eines entsprechenden Kurators, eines Menschen, der dann die Stiftung, die bereits gelöscht war, überhaupt vertreten kann, und dann 4 Prozesse in der Sache, Landgericht, Obergericht, Oberster Gerichtshof, und dann wurde es nochmal weitergezogen von Badliner zum Staatsgerichtshof.
Dr. Badliner hat das alles verkraftet. Er ist immer noch Millionär. Klaus Lins hingegen ist gescheitert. Sein Leben nahm einen bitteren Verlauf.
So, da vorne rechts, das haben wir jetzt das Haus, das ich hatte. 1988 bis 2001 habe ich da drinnen gewohnt. Und habe das dann verkaufen müssen. weil ich natürlich die Strafe vom Dr. Battliner zahlen haben müssen und zur gleichen Zeit auch die Scheidung gehabt. Ja, und praktisch alles verloren. Und nicht nur praktisch, ja, absolut alles verloren.
Eine unglaubliche Geschichte. Ohne Happy End.
Okay, thank you very much for your patience. Thank you very much.